Here, look. Good morning. We're in Senate Judiciary. It's April 17th. We're taking up the miscellaneous Judiciary bill, H 937, and we have Ledge Counsel here to provide a walkthrough. The floor is all yours.
Good morning. For the record, Michelle Stiles, Office of Legislative Counsel. And we're going to take a look at H 937 as it passed the House, but I'm just going to go through some of the sections with you. Because you know, Eric generally does the miscellaneous bill, but a few of my bills made it into the miscellaneous bill. There are two that I'll just mention right off. One having to do with public dissemination of electronic criminal records. That was its own bill, and small. They decided to include that in here. Another one has to do with statute of limitations for judgments in family division. Same thing. And so those are sections 4 and 5. And then when H 937 was on the floor for debate in the House, there was a proposal amendment offered looking at including some language with regards to expanding rapid accountability dockets through statewide. And so House Judiciary kind of paused the bill on the floor and took some testimony, and we worked for a couple of days on some language with stakeholders. And then there was an amendment that they came up with, and it was offered by Representatives McGuire and Lamont on the floor. And so that's sections 31 through 40, and that has to do with the rapid accountability body. So those are the sections that I'm going over right now, and then Eric will come in and go through the rest of it. So for my sections, if you turn to page 7, and we take a look at section 4. So this is in Title 12, so on court procedure around dissemination of electronic case records. So this statute was originally adopted in 2007, and it applied to specifically criminal and family case records. In 2019, the General Assembly added probate case records as well. And this has to do with public dissemination. So as you know, the chair knows very well, lawyers have access to all of these records through a certain system. The public can obtain copies of certain things if they go to the courthouse. But there's current prohibition on making these records publicly available through electronic means. And so I think the House was approached by media saying that really slows their ability down to not be able to access the criminal records electronically, but having to actually go to the courthouse to do that. And that in today's age, you know, when the statute was originally adopted in 2007, it was kind of a different world in terms of the internet and the flow of information and reporting on criminal charges. And so what they did is they eliminated the prohibition on electronic dissemination of criminal case records. And so that's just striking through the language that pertains to that. And then you'll see on page 8, there's a new subsection C that procedures governing public access via the internet to criminal case records are to be established in court law, which they have already.
So those rules for non-lawyers, if they're, well, actually there are no rules because non-lawyers can't access it, right? Unless they go to the court.
These, yes,
Yeah.
correct.
Yeah. Okay. Okay. Thank you.
Yeah. And so when you're taking testimony, I'm sure you'll have this word in and we can speak to this.
Any questions on this part?
Yeah, just a quick one, Michelle.
Yep.
Did they have access to only those records where someone was found guilty, or just anybody who was charged with anything and still?
I think the scope of that is going to all be in the rules in terms of it wouldn't be expanding public access in terms of the material itself. It would just be the method of access. right? So you wouldn't be able to get something that you couldn't if you can't get it by going to the courthouse, you're not going to be able to get it electronically. And I think the court can talk to you about the scope of what is accessible now, and I can send y'all the rules.
So when John Q. Public goes in, do they have to, is there a fee for obtaining hard copies through the post?
Most likely, but I think,
I've never been to that.
yeah, I use the electronic system, so
So there's no fee for this then, or?
of accessing electronically. I don't know what their proposal will be because they're gonna adopt rules with regard to access for dissemination through electronic means. So they should probably talk to you about how they would do it, but it would go through rulemaking. And those rules, as you know, in their proposed stage, they come before, the short rules.
The somewhat ironic part is, at least in the Wyndham Courthouse, there's a computer there that's connected to the internet where anybody can walk in and just access the criminal records, but you can't access it from any other computer. I mean, hard copies, I don't know if they charge you for that, but maybe they do, but yeah, it's open, accessible to anybody as long as you go.
Because it's gone to the court.
Yeah.
But you're still accessing it electronically on the internet.
Yeah.
So
But in the courthouse.
I would envision it like land records, I would have to go to the town clerk's office, go on their computer, and then it's opened up now to the point where you can just go online, do that same thing, purchase the document, and you have to pay a fee for each page, just like if you're in the town clerk's, like in Milton or a bucket page that you print.
Yeah.
So I'd imagine it'd be similar to that.
Yeah. But yeah, no, those town records of it, over the last 5 years, they've become more accessible from computers that aren't in the town clerk's office, and it saves
Oh, yeah.
the title searchers and the clients hours and hours of time.
Oh, yeah.
Just, yeah, absolutely. That is,
So I'd envision it like that, right? This change.
yeah,
Right.
But with the charging for the hard copy, I don't know, I mean, the courts can set that rule, so.
Okay. So section 5, this is on page 8 at the bottom of the page, and this is also in Title 12, and this has to do with statute of limitation for judgments. So judgments are not valid forever. They have a statute of limitations, and which, if the judgment is not renewed, then the obligor no longer is subject to pay. You'll see the language in subsection A that existing, so actions on judgments and actions for renewal or revival of a judgment are to be brought in the civil division of Superior Court. That's just a little technical, by filing a new and independent action on the judgment. And so I looked back on a little bit of the criminal along with the history for this. You'll see that, so in subsection A, there's an 8-year statute of limitations, and then after 8 years, you have to renew the judgment. So in 2010, the legislature amended the statute regarding renewal of a judgment and a mediation bill that had to do with mediation and foreclosure proceedings, and made the change around that if you wanted to renew a judgment, you have to file a new and independent action. Some issues came up with that. There's a case in 2020 about that applying to family division judgments, right? So if you think about from a standpoint of being able to easily maneuver within the courts, right? So you have family division, there might be an order that is issued for maintenance or property division, or somebody's going to stay in the house with the children, but once the children have, fled, then the person is obligated to sell the house and split the proceeds with perhaps with the other partners, things like that, right? And the idea, the concern came up with is that, I think, and from the testimony in the House, was that some practitioners didn't realize that this was going to be required for the family division orders for money or property. And so what it means is that you have a family division order, and then you have to go to the civil division to renew the judgment. So and as you know, in family division, you have a lot of pro se litigants. And so the Vermont Bar came to the General Assembly and asked some members to introduce legislation with regard to this, addressing this specifically around the family division orders having to do with money or property. And so that's what the language is that you have in front of you. So I'll walk through it a little bit. Also, there was, as I mentioned, there was a case in 2020, the Petrie case, and I can send it to you if you're interested. And in it, I'll just read because I thought it was illustrative. It's in Mrs. Robinson's concurrence. She said, application of the requirement to divorce orders gives rise to unnecessary confusion and cost for divorce litigants who may be forced to simultaneously litigate some post-judgment issues in the family division while litigating others in the civil division, and it imposes an additional burden on the court system. Amending the statute as it is here, so that a motion to enforce property judgment in family division pursuant to the family court rules can serve to renew the judgment for purposes of the statute and would not undermine the goals. And she says, for these reasons, I urge the legislature to revisit the statute. So that's exactly what this is going. So again, back to the language, bottom of page 7, so section 4, oops, I'm sorry. Bottom of page 8, subsection A. That's just a technical, adding in the civil division. And so top of page 9, subsection B, we have notwithstanding that section, that family division has exclusive jurisdiction over actions on judgments issued by the family division, right? So it's carving it out there. We see in subdivision 1B1, starting on line 4, that it's for money or property, as I mentioned, and it sets forth the process for renewing the judgment prior to the expiration of the 8 years on the initial judgment.
Michelle, can I ask a general question? And this might be a question for Bob, but can you share why somebody would need to renew the judgment? What purpose would it serve?
You want me to? You don't want to
Whoever.
Bob Paolini from the Vermont Bar Association. The example that was used, I believe, upstairs in the House Judiciary's testimony was perhaps a maintenance order or a child support order for a very minor child, a 4-year-old child that would require payment for 14 years, basically, until that person reaches majority. Question, if the obligor continues to make those payments over 14 years, even though the judgment is over 8 years old, is there any reason to have to renew that judgment? And I think what you're looking at here, that Michelle has drafted along with our 2 family lawyers, is that if there's a breach in performance, then that starts the clock running, and the obligee would need, in that case, to approach now the family division to extend the judgment. I think that's the example that our lawyers were trying to fix.
Thank you.
So that example of child support, you got 14 years of child support. You don't have to worry about the 8 years there. It's because that last payment or action is required.
Right,
After
we'll
that.
skip down a little bit to the language down here that shows the things that will restart the clock, essentially. Subdivision 1 is about how you go for the procedures for renewing a judgment through the court. But if you look at subdivision 3 on line 16, so any of the following shall restart the statutory limitation. So the first is a written or signed acknowledgement of the debt, action, or obligation. So somebody writes, I owe you this money, I haven't paid my whatever, but it's debt. The second one on line 20 is any payment made by the obligor on family division judgment, including by a wage withholding order. So in the circumstance when you're thinking about a child support order, let's say someone it's for 14 years, someone pays for 8 years and then says, so I don't, and then stops paying, right? Or is paying intermittent, right? Is under this provision would be that you would look at the payment, the last payment made by the obligor, and then the clock would run from that point because they've been complying with the original order. So rather than requiring every single person who has a judgment that goes beyond years to have to go into court and refile to review the judgment, they would use a certain point in time that you've been, there's a valid judgment issue, you've been complying with it. So when was the last payment you made? And then the 8 years would run from there. And it wouldn't extend it beyond the original order, so it would still be the 14. It doesn't extend beyond that, but it just means that you wouldn't have to go into court and file a new action. And then similarly on page 10 in subsection subdivision C is any affirmative action taken by an obligor towards compliance with the provision. So similarly to like making a payment, or D is that if anybody makes a payment on your behalf.
Michelle, I don't know if this is a title. It's supposed to say any affirmative action or any affirmation action. Like,
I think affirmative would be better. And then I can remember if I mentioned it to you already or not. I think is that it doesn't apply to orders awarding or conveying real estate. So it's around money or property. And then and subdivision 4 is the end there on page 10. It's just that all property or money judgments that are issued by the family division have to contain that language around the renewal. Okay. All right, so now we're going to skip on to page 29, and we're going to start looking at the sections having to do with the rapid accountability docket. So I know that y'all have taken some testimony and are familiar in general with the Chittenden County project. What these next sections do is look at how to kind of lay out a plan for potential expansion statewide of these particular type of dockets. So you see on page 29, section 31 starts out with some findings. That first finding being about the success of the pilot accountability board in Chittenden County, and then continuing on page 30 talks a little more about some of the positive outcomes of doing that particular docket. And then if you go down to subdivision 5 on line 12. It says that each county that determines that employing a rapid accountability docket modeled on the Chittenden County pilot that takes into account the unique needs of the particular county should have the opportunity to operate a docket. So one of the things they were trying to do was say, how do we kind of model that pilot, but leave enough room recognizing that every county is different, right? And what was needed in terms of resources or such in Chittenden County isn't necessarily what's needed in Franklin County or in Rutland, that every county may look a little different. So if you look at section 32, it lays out some purposes of a rapid accountability docket. I don't know, do you want me to go through those or just?
now we find.
So during the house bill, findings, then purpose. Then
Sure, there's a special.
strategy, all I need purpose.
No study.
strategy.
There's some reporting. But
Is there a study?
No, there's.
Oh, that would be fun. Maybe we can have one.
So the purposes that are set forth, and this is kind of just to be guidance for any docket that is adopted in a particular county, it goes through towards the bottom of page 31. Section 33 is the county deployment strategy. So just want to think about it's not like they're all going to come online at one time. And once you have the stakeholders in here who are participating in this, they can talk to you about what they kind of envision of how it will roll out. But you have kind of the folks you need at the table. So you have DSAS in consultation with Defender General and Secretary of AHS are to recommend to the Chief Superior Judge the counties that they identify as appropriate for the rapid accountability docket and the order in which the county should implement the docket. So they're going to look and say, okay, we can get more here, here, here. Maybe some counties don't have the resources, right? The community resources are such that that would lend itself to doing this type of docket, or they might not have a lot of folks who would necessarily qualify. You'll see on line 2, it's at least 30 days before a docket starts in a county. The state's attorney in each respective county is convening all the stakeholders in the county to assess the needs and the resources within the county to develop a plan to implement the docket in accordance with those purposes that are in section 32. Section 34 is the resources that are dedicated from the judiciary. So see subsection A, Chief Superior Judge assigns either a sitting or retired judge to each docket, and the court administrator provides a dedicated courtroom, court staff, and court security to implement the plan for the respective county. Subsection B is that each operating period for the docket is to be 90 days, but it could be shorter if the goals are met before that time, as determined by the judiciary in consultation with the state's attorney and the public defender. And you'll see line 14, each docket is to give priority to defendants with 5 or more pending cases, but the state's attorney or the public defender may request to include defendants with fewer than 5 pending cases where faster action would serve the interests of justice. So it gives them a little bit of room to kind of maneuver in terms of who are the people most needing that rapid accountability docket in each county. Section 35 is the dedicated prosecutor and the public defender. So the governor, in consultation with their respective state's attorney and DSAS, is to can appoint a special prosecutor to serve on the docket, or the state's attorney of that particular county can assign one of their deputies to do that. Subsection B is that the DSAS is to provide victim advocates and administrative staff sufficient to implement the plan. And C is that the DG is to identify a lead public defender for each docket. Section 36, and these are the executive branch resources. So the governor is to dedicate resources from DPS, DMV, DOC, Department of Mental Health, and HS to implement the plan for each county because they all have a role. You see in the subdivisions there, DOC has to assign a liaison to each operating docket. DSAS, law enforcement, and other folks have to work together to ensure timely transportation of incarcerated defendants to the court.
Michelle, question regarding DOC and the liaison. Was there any conversation as to why that would be necessary when if we're talking about a defendant who is getting transported, they already have a case manager, and I know that when you open the door to adding more people, it can create some unnecessary redundancies or bureaucracy to it. Was there any additional conversation about that?
I think probably the witnesses can talk to you about this. Again, this was using the model that was employed in Chittenden County, and they felt as though having a DOC liaison as part of the process was an important piece. But I would leave it to them to kind of make their pitch as to why. Subdivision 3 is that the Secretary of AHS is to assign staff to each docket to address complex needs of defendants who might be dealing with substance misuse or homelessness, that sort of thing. Page 34, subsection B is the governor in consultation with Secretary of AHS and DSAS, and the chief prevention officer can designate a rapid accountability docket coordinator to assist with the deployment of resources. So this was discussed quite a bit about, because you do have a number of folks who are involved in this, does it, be a real benefit to having someone who's going to help coordinate the services and make sure everybody is talking to one another. But it is discretionary. Subsection C is that the administration is to coordinate executive branch review sources to track and report data. So not a study committee, but a report, and ensure that the information is maintained and distributed to evaluate the programmatic efficiency and dispositional outcomes. So section 37 is just the things that the data they're supposed to be collecting.
So I have a question, and it's, so I looked at the stuff they're supposed to be collecting, and I logically moving people through the system quicker and getting them the support they need would save the overall system money. But I don't see anything here sort of tracking the cost savings, because what I'd really like to see is how that cost savings reinvested in the system, but I don't know if you can think of a way to actually track that savings. Does what I'm saying make sense?
I know
Okay.
exactly what you're saying, you know, kind of justice reinvestment. I think,
Yes.
right? So, how do you do that? I would say that that would be something more for the people who are going to be collecting the data, providing the data. How do you quantify that? I don't know whether or not CRG would have input on something like that. That was not something that I recall being discussed.
Yeah, I don't see it represented
in
here
the
at all.
house. The other things were kind of done collaboratively in terms of the data.
Okay, I'll talk to other witnesses, but I'd like to sort of put a flag on there that in that data reporting, I'd like to see that sort of savings data with a requirement that it be reinvested into the system.
Okay, so paper close, almost done. Page 35 and is section 38 is on the reporting. So DSAS, DGHS, and the Judiciary are to appear at the August 2026 Joint Legislative Justice Oversight Committee, just to report on the progress. So it's not a written report, not a study, anything like that. It's just like, let us know how this is going so far. Then you'll see in subsection B is that on or before December 1st, Secretary of Administration is to submit a written report regarding the implementation of the accountability dockets to the Senate and House committees on Judiciary as well as the governor. Section 39 is just contingency funding, which I'm sure you've seen in other places. Section 40 is a repeal of all those sections as of July 1st, 2028. So this is just as a kind of a 2-year window, and assuming that you'll be using the information that's coming to you from the programs, how they're functioning, and revisit the issue before that expires. And then, so that's it for my walkthrough, but I did just want to mention one other thing, which is, I have a proposal for you, and I think I sent it to Emery yesterday, and it's not something you necessarily need to review right now, but when I was reviewing S-183, the home improvement fraud bill, to go to the governor the other day after it passed both houses, I noticed a technical error down at the end of the bill with regard to a cross-reference. But because it had passed both houses, it's not anything I could do anything about at the time. So I drafted an amendment to go on to miscellaneous judiciary and provided it to Eric as well as both chairs. I also I reached out to the AGO and DSAS to make sure that it wasn't supposed to be there for some reason, but we all missed it, and just and so what I did is I drafted the amendment to just fix that tiny technical amendment, and then it was taking effect July 2nd of this year, because S-183 takes effect on July 1st, and so it would just the next day would just revert back. So hopefully no harm, no foul. And I did reach out and send a message to the governor's council explaining that, and that there would be a little tweak to that in the miscellaneous judiciary bill.
Great, thank you. So we have almost 15 minutes, and I know, Eric, you have some parts in the miscellaneous bill.
Right.
And then after we go through most, if not all of your parts, then we can get it to 3 time. Does that work?
Yeah, work for me. Yep. Good study the report and
Findings for this.
There's findings in like every section, right?
Things are important.
You have to find out which stuff.
Reporting.
Morning,
Morning.
Eric Fitzpatrick with the Office of Legislative Counsel here to continue the walkthrough of the miscellaneous judiciary bill that Michelle began with some of her sections. So mine began right at the start of the bill on section 1. No findings, you'll notice right there. So we'll proceed right to the substance. And that is, this one is just purely a technical thing. You'll see all this language regarding profits from crime. That's an existing subchapter of law, but it exists elsewhere in Victims' Compensation Board statutes. And that profits from crime subchapter allows the Attorney General or a crime victim to bring a lawsuit to recover profits from crime. You know, a situation where someone who's been convicted of a crime, maybe is writing a book or something like that they're making money off it, and there's this legal action that's permitted. But this chapter is enforced by, subchapter, I should say, it's enforced by the Attorney General's office, not Victims' Compensation Board. So it kind of made sense to have it be, and what it's done here is verbatim, no language change. It's just picked up and moved from the Victims' Compensation Board statutes to the Attorney General statute, title of the chapter here, I should say. And both the center, this was at the request. And I'll point out as I go through these, many of the miscellaneous provisions were requested by a certain party or entity, and I'll note those as we go through. This one, for example, was requested by the Center for Crime Victim Services, but both the center and the Attorney General have agreed that it makes more sense to have this subchapter located here. So that's all that is. It's a lot of underlying language, but it's just moved from somewhere else. And as we go further, you'll see places where it's struck from existing law. Remember that it's not struck, repealed completely, it's just moved, and that's why we just looked. So that brings us to section 2, page 4. This is a request from the Court Diversion Project in the Attorney General's office, and it involves the civil violation in existing law for when a minor tries to buy alcohol with a fake ID, or a minor possesses alcohol or possesses cannabis, consumes alcohol. That's all existing language, page 4 over to page 5. So this involves the penalty for that.
I do have a question about the existing language, and it's interesting that it's coming up here because this section is also in the technical corrections bill.
Are you referring to the profits from crimes law?
No, the section 2.
Okay, gotcha.
Is this indicating that if an 11-year-old possessed wine or cannabis, that's not a problem? It's only if they're between 12 and 20?
It's indicating that that person could not be charged with a juvenile offense, which is consistent with the juvenile law, the minimum age as well. That person could be, there could be a DCF proceeding brought involving that's a child in need of care supervision sort of situation. But yes, that it's true that someone younger than 12, a juvenile offense can't be brought against the person generally. And that's why you'll see line 4, page 4, that Senator Hobbs mentioned, a person of age 4 or older can be have a charge of possession brought under this statute, but that's the way the juvenile structure works.
Yeah, I also, never mind, this is, thank you.
Yeah.
I had asked the question of Maria when we were going over technical corrections the other day and realized I actually should ask you. So here we are. It is in the technical corrections bill.
Well, on that same issue, because it gives us a nice segue, if you turn over to page 6, line 9, also, this is a request from the judiciary that noticed that language we were just talking about, the 12 years of age or older, which is necessary for consistency with juvenile jurisdiction generally, for some reason does not appear. This is the tobacco, the parallel tobacco provision that we have to alcohol that we were just looking at. So the proposal here is to true up that jurisdictional piece. So it adds the language line 9 and line 13, 12 years of age or older. Same idea. If you're 11, it'd be a DCF chins proceeding. It wouldn't be a juvenile proceeding. All right. So turning back for a second, back to section 2, the substance of that, as I said, actually relates to the penalty. So when a charge is brought against juvenile for one of these violations, they're referred to the Youth Substance Awareness Safety Program, and if they don't complete that, then the penalty is a suspension of their driver's license. For one of the types of offenses, which is the .02 violation, that language has an automatic reinstatement of the minor's driver's license after the period of suspension, 90 days. But, and what the, court diversion program director thinks was just an oversight, that automatic reinstatement doesn't exist for A, B, C, and D, for the alcohol possession, cannabis, consuming alcohol, etc. So that's what this does. Over on page 6.
Eric Thunderbolt's, yeah.
Oh, yeah.
Yeah, so the automatic suspension of the driver's license applies to all of these things, which, okay, but it also applies to people who presumably don't have a driver's license because they're not 16. So how does that, do you see? Like, so the penalty is an automatic suspension of the driver's license, but a 12-year-old doesn't have a driver's license, so then what?
Presumably that would apply if you don't have a license.
Okay,
Does it tacked on? If you then become 16, get your driver's license, do you have a suspension?
I don't know how that works.
Basically, sure not. Everyone thinks if you lose your license, you actually, you're privileged to operate a motor vehicle on a public highway is suspended. It's nice to have a little piece of card that says it's a driver's license, but you're privileged to operate a motor vehicle on a public highway is suspended. So you don't have to have a driver's license. You just lost it. You're up to ride a vehicle on a public highway.
Right, but if you're 14, when you lose it for 30 days, you don't get your license until you're 16. Do you actually,
Kick in that.
does it kick in that 30-day period? Like your first 30 days?
Question,
you
I
can't drive?
don't know that.
I think that's a DMV question.
Yeah, I suspect there are fees you have to pay, and if you don't pay the fees, then probably don't get reinstated, and then it kind of lingers. I'm speculating, I don't remember, but it's a good DMV question.
So that piece aside, what's going on here is that if, let's assume the person is old enough and they actually do have a license, and they don't go to the youth substance awareness safety program like they're supposed to, then the penalty for that is this license suspension for a specific period of time. This provides, goes to page 6. After that period of time, it gets automatically reinstated.
Yeah, so I was about to say, it's automatically reinstated then, you know, if you're 13, and you lose it 30 days, they're getting automatically reinstated. So when you're 16, you go to get your license. I would suspect it's not an issue, but
There is no penalty then.
yeah, I guess
Between 12 and 16, there is no penalty.
No, that's only a portion of the penalty. You also have a civil penalty of $300.
Minus $3.
Right.
So you're out of there.
Yeah, $300. But I don't know, it's an interesting question. So if you didn't have a license, could it be suspended? So maybe this, you know what I mean? So like maybe if you were 14.
Or if you were 17.
What's that?
Or if you were 17, you just didn't have a license.
Yeah, that's true. Right. Again. Interesting question for you, DMV offense.
We need some findings as to where this.
And stuff.
and those penalties only go into place if the person doesn't go through the sort of restorative educational treatment process that we have laid out.
Exactly. Yeah. Yeah, they don't apply if they go through that program. It doesn't never get suspended at all. All right, so that we talked about section 3 already on page 6. That was just the 12 years and older piece.
Did we deal with this section of law in the tobacco bill? I thought we made changes to this in that bill. I can't remember the number of the bill.
Yeah. That.
This year, you mean?
Yeah.
Hmm.
It's, that bill, I think, is in House Commerce.
What was it?
I thought we eliminated the fines for tobacco possession.
But then there was an amendment.
There was an amendment and I had asked questions, and I want to check with Allison about this because I had asked questions about moving in tobacco possession to the youth substance abuse prevention, safety, whatever that's called. Because I feel like because the stated goal of the changes we made in the tobacco bill was to get kids treatment. If that's the stated goal, we have a system for that for alcohol. Why not just move tobacco into it?
Mm.
You know what I mean?
Yeah, and I can't remember what that would be.
Leaving aside the policy discussion for you guys, I will follow up on that bill just to make sure that there's nothing inconsistent.
Okay.
So if they both pass, we have to make sure in our office that there isn't anything contradictory. If there isn't, even if it gets past two places, it can be harmonized by our office, but still, we have to run on the same page. So
I think there will be inconsistencies based on what we did in that bill and this.
Right, all right, I'll follow up.
Thank you.
You bet. That brings us to page 7. I think Michelle already talked about, this is section 4, the electronic case records piece, so that one the committee's already seen. Same with section 5, which begins on page 8. This was the judgments in the family division, the renewal of judgments, so you talked about that piece. That brings us to page 10, section 6. Purely technical here, you'll see the word district court being changed to superior court. We don't have district courts anymore since the Judicial Restructuring Act 2009. This was a member of the bar, flagged this over the summer, brought it to my attention. I put it in my miscellaneous file, so that's here being corrected. Another technical issue, page 11, section 7. This was brought to our attention by the Judiciary. This section is being repealed because identical language was enacted elsewhere in statute, 12 VSA 4939, when the mortgage foreclosure statutes were restructured in 2011. So you don't need it twice, so it's being repealed here. Section 8 and actually section 9, both these next two sections deal with stalking. Both remember, the stalking had both the criminal, the crime of stalking. There's also a civil procedure where someone can get an order against stalking, like a relief from abuse order, that kind of thing. So in both cases, though, stalking requires that a course of conduct be proven. You see that on page 11, lines 89. So that's the stalking relies on the establishment of a course of conduct, and a course of conduct is defined as 2 or more acts over a period of time, however short. However, there's been some reporting that some courts have required that 2 acts have to occur on separate calendar days. So, in order to clarify that that's not the case, you look at page 12, lines 4 to 5. Course of conduct shall not be construed to require that the 2 or more acts occur on separate calendar days. So
Eric, do you know what the court rationale for that was when the language, when the definition of course of conduct was 2 or more acts over a period of time, however short?
I do not. It was something that was reported anecdotally by a member. Not a member that I ever saw.
Of legislator?
Yes, exactly.
Do you know who?
I do. I'll follow up.
Okay. Senator Mavis.
I was, after Senator Vyhovsky mentioned the previous bill we passed, I had to go look it up because I was very curious. And we actually did change quite a bit in S-198 as it pertains to this, section 3 of page 6. Based on what we did in S-198, we actually crossed out pretty much all of that section, subsection 1005, and really just kept C. And kind of even changed that language a little bit to a person under 21 years of age. So I think that encompasses even the children under 12 in that case. So there's some big discrepancies there based on what we passed. And then also an action under this section shall be brought in the same manner as a traffic violation. So the 23 VSA chapter 24. Don't know that one off the top of my head. Right.
Yeah, I had a feeling it was going to be pretty inconsistent, but I also think this, I was going to bring a floor amendment around bringing them into the youth safety program. The committee chair and I decided it was too complex to do on the floor, but I think this brings it actually into the jurisdiction where that conversation should happen.
So again, that point aside, our general approach to harmonizing statutes is it has to be in a contradiction. So in other words, if you passed a bunch of things in another bill that aren't touched here, and this one says 12 years of age or older, we harmonize them in our office by putting both in. So but if your other bill said, for example, 10 years of age or older, that's a contradiction.
Oh,
Struck this whole section.
It struck everything besides C and even changed C.
Yeah, that's
It's pretty contradictory.
Sounds like something we'll have to revisit.
Yeah, it could be that, one easy way to address that could be strike this section from this bill. Take the 12 years of age or older language and put it in the tobacco. That's one possible option. Or the reverse. Although it sounds like the tobacco bill has got more to it. Maybe it's not something that should be miscellaneous, the whole that whole bill, in other words. Anyway, just an option. Just think about it yourselves as to how
I
you.
think there's a couple things to revisit here.
Right.
So I just flagged it.
All right, so we just talked about the course of conduct, clarifying that it doesn't require that the two acts occur on separate calendar days. That was the civil action that I was just talking about in section 8. The exact same change in section 9, which is the criminal action. That takes page 12, 13. That takes us over to page 14. Section 10, purely technical, just changing reference from section to a subchapter. Section 11, this was requested by the Center for Crime Victim Services under existing law. And when a law enforcement agency investigates a crime, they have to give certain information to the victim.
Report information.
This is more of a information that's provided by. So the list of what has to be in that information that the agency provides to the victim is an existing law, page 14. You see one, all the way over on the top of page 15. And that list, as it happens, is in a form that the Center for Crime Victim Services provides to law enforcement agencies, and they provide it to the victim. So this adds one piece of information over on the top of page 15 that has to be in that form about the victim's right to know if the defendant is at a correctional facility, where the defendant is held, how to locate the defendant if they're released, etc. As it happens, that information is already in the form. So it's kind of correlating the statute to existing practice. So that's what we're doing. Page 50, you'll see this is just repealing the existing profits crime sections. Remember I mentioned that they went over to the police office. Bring to page 60. Section 13, sorry, page 7. Sorry, line 7, page 60. This has to do with the composition of the Victims' Compensation Board. This was also requested by the Center for Crime Victim Services. Currently, people on the board, you see lines 11 and 12, 5 people on the Victims' Compensation Board appointed by the governor, one of whom had to be a physician. So this is expanding that to be, it can be any healthcare provider. Doesn't have to be a physician. In other words, it could be anyone. And that definition that's cross-referenced says any person licensed or certified to provide professional healthcare services in the state. So it could be a registered nurse or whoever. Next section, again, that's more repealing profits of crime stuff. That's over on page 17, line 4. So he's striking that. Section 15. This is a number of years ago, the legislature, also requested by the Center for Crime Victim Services, by the way, but several years ago, the legislature amended the amount of money that could be advanced to a crime victim in the restitution fund. So in other words, prior to conviction under existing statute, there can be an advanced payment to a victim. It was $10,000 when the statute was initially enacted several years ago. That $10,000 was the maximum, I should say, and that maximum was lowered to $5,000. But there's a couple of places in statute that we neglected to change from 10 to 5 in every place. So it's changed in a few places here and a few other places that we'll see as we go along. That brings us to page 18, section 19. Actually, that's all more profits of crime existing statute being repealed. Brings us over to page 20, section 18. That's another change, $10,000 to $5,000 change that I just mentioned. The advances, that's lines 19 and 20. Brings us over to page 21, section 19. This is a request, another one from the court diversion program. It deals with the records, pretrial risk assessments, and need screenings. Currently, those records are confidential, exempt from the Public Records Act. That's page 21, line 10, existing law, 37 from public inspection and copying. And then after that, they have to be retained for 3 years, but the state policy on records retention is 2 years. So over on page 22, line 14, that period of retention is changed from 3 years to 2 years to be consistent with general statewide retention policy. Section 20, page 22. This is a request from the Judiciary and specifically from the Advisory Committee on the Rules of Probate Procedure. And it involves spendthrift guardianships. There are a number of statutes on spendthrift guardianships on the books. They're never used anymore. They're archaic and outdated. So the Advisory Committee requested that they be repealed.
What was the advisory committee?
The Advisory Committee on the Rules of Probate Procedure. And a question that often comes to people's minds in that, in this is, well, what's a spendthrift Guardianship. Well, that is, and they'll tell us, language kind of indicates why it's archaic. It's a guardianship for a person, quote, who is liable to be put under guardianship on account of excessive drinking, gambling, idleness, or debauchery. So not used anymore by the probate court. And, but at one time it was. So that, those sections.
I introduced the bill that we see those coming from Vermont, so.
There you go, put them together.
All right, so that brings us to section 21, page 23, purely technical. This is something that our office noticed in the interim usage of the missing conjunction on line 18, missing and. Very important. Yes, gotta have those. Yeah. Courts could be confused. Page 24. This is section 22, a request from the judiciary. This is, you may recall, the days of day bill several years ago. This, in connection with that, the court and does now, when a time period involving a court proceeding is in rule or statute, they try and use multiples of 7 days, 14 days, 21 days, etc. So you'll see line 16 on page 24 changing a 15-day to a 14-day period versus when a court has to schedule a case, because they prefer to use multiples of 7 now, works better with weekends, that sort of thing. Also a request from the judiciary, the next section goes over on to page 25. This is under current law, a certified copy of a child custody determination has to be sent to the court administrator, but that's not necessary anymore because those can be filed directly into the court's electronic case management system. So you don't have to make a certified copy and send it in the mail. So that's all that does. It moves that file, that certified copy file provision. Section 24, correction of a cross-reference, also very technical, noticed by the court and the diversion program, over on page 26, actually twice on page 26, 2 sections correcting the same cross-reference. That youth substance abuse awareness program we were talking about earlier isn't not in statute, that we're being referred to here. Brings up to page 27, which is a request from the Vermont Bar Association, the Vermont Bankers Association, Vermont Attorneys Title Company have all agreed on this section. This is a little bit more complex.
Addendum clause.
Yes, the addendum clause is that when the transfer of property, the addendum clause defines the type of interest being transferred. Whereas you'll see the previous few words, the grant clause actually transfers the interest. That's doing the transferring, the addendum clause defining what type of interest is being transferred. The reason this matters is because it has to do with jointly owned property. I know we've talked about that in this committee before. But if you own property with another person, you own the property joint. 2 most common ways to do that are joint tenancy with right of survivorship and tenancy in common. One of the primary distinctions between these 2 things is joint tenancy with right of survivorship. 2 people own it in that way. If one person dies, their interest goes to the other owner. Right? So then the other owner owns all of it. On the other hand, tenancy in common. 2 people own it as tenants in common. One person dies, their interest goes to their heirs. Could be their kids, their friend who they wanted to bring it to, will it to, or transfer it to. It could be the nieces and nephews, whoever. It doesn't go to the other owner. It goes to their heirs. So, and you can decide, whoever's doing it, it's up to the owner to decide which way they want to do it. In some circumstances, you might want to have your interest go to the other person you co-own it with. In other situations, maybe you want it to go to some other people. You can decide how you want to craft the deed and the other transfers of property, however you like. This responds to a recent Vermont Supreme Court decision called Kirsan v. Abadili Mills, which held that certain language in a deed would always be interpreted to create a tenancy in common. As it turns out, according to the Bar Association, the bankers, the title company, that in fact, that language has always been interpreted oppositely, to actually create a joint tenancy, not a tenancy in common. So this language, all those folks have agreed on this, that the language here clarifies that, hey, when that language appears in the deed, it means it's a joint tenancy, not a tenancy in common. So in other words, you would have the right of survivorship rather than going to the heirs. That's the difference. All right, so moving, and the next section actually is related to that. What we just talked about, see page 28, section 27. This is a retroactivity piece to what I just described. So that interpretation of these, because ordinarily, when the legislature makes a law, it applies prospectively. You can make a law apply retroactively, but you have to say so, and you have to, line 2, page 28, you have to notwithstand the statute that exists in current law that says laws generally apply prospectively. So you say, notwithstanding that, section 26, which is what we just described about how these deeds are going to be interpreted, shall apply retroactively. So even if the deed was created 5 years ago, that's how it's going to be interpreted, unless there's already litigation that's begun around a particular case, particular deed. In that case, it doesn't apply retroactively. All right, section 28, page 28. We're almost, actually, we're just about done. A member of the Bar Association pointed this out to me as well. Deeds don't have to be sealed and witnessed anymore. This is a statute, and when that change was made, the corresponding change was neglected to be made here. So you see line 8, striking the requirement of sealing and witnessing. That doesn't exist anymore, generally speaking, for property transfers. Section 29. This was an interesting, I know, it's actually brought to our attention by the Sergeant at Arms, who passed it along to Representative Oliver.
It was $3.
$3. So under current law, if anybody finds any property that's worth $3 or more, you have to post it in 2 public places in the town where the property was found. And evidently the Sergeant at Arms was like finding people's water bottles around and stuff. And like, oh, that's worth more than $3. So, so you'll see the proposal here is to increase that to $50 minimum, rather than $3. So this was something, as I say, that the Sergeant at Arms brought to the attention of Representative Oliver upstairs.
So you can just post a piece of paper on a telephone pole? What did I say you have to post it in the paper?
You know, it's in 2 public places.
Okay.
So I haven't heard of any prosecution under the statute, so I don't know how they interpreted that. They say it's not public enough. Obviously an older statute. It's being updated.
Let's take some stray beast.
Yes, I noticed that too, right? There's some other interesting that they have, it's in there. You also have to.
Natural or artificial.
Right. Yeah. Yeah.
Any
That's
questions?
really interesting wording.
Any questions for Eric?
The very last section, just another change, section 30, page 29, just another update. As said, Professor by the Judiciary changing a 10-day period reporting. All right. And that's it for that one.
Great, thank you.
You bet.
So sure there'll be some additional changes to 937.
Right?
I've got a few that I'll send over. So we'll switch gears to S329. And so I'll ask Senator Ruth, you could provide the explanation as to
Sure.
why this has come to be. And,
Yeah. So, first thing I'll say about this is it is word for word what was already on the table. So it is H606 and the amendment that I had put on the table, put into one. So no changes from that place where we was. So all of the testimony that we took still applies to the various sections in here. And what I said to the Rules Committee was that the House leadership and I had been talking about the Burlington Charter for a long time, and they had given me to understand that there was a path forward for that, which once the relevant deadlines had passed, then suddenly there was no path forward. Which left me in a position as somebody trying to move the bill at a disadvantage procedurally. So I went to the Rules Committee. Rules Committee is allowed to waive both the drafting deadline and the crossover deadline. So I made that case to them. The Rules Committee waived those deadlines. And so this dropped into committee in my mind as a replacement for H606.
Any
question for Senator Ruth. All right, so we can go through markup. I mean, there is still the piece that I want to add to this regarding the relinquishment language. That we can additional changes to that as we move along, but maybe that's not being added today. Still got to tinker around with it, but so section 1 is the grand larceny section, and that is the one that firearm of any value would be considered a firearm of any value that is stolen would be a felony. Is that correct, Eric?
Exactly, yep.
How do folks feel about that section? Or are there any changes?
I will say in my discussions with Timmy and Chris Bradley, the first, what was H606? So that would be right up to the bottom of page 9. They seem to have very little problems with. I won't say that they're in favor because they generally, their organization usually favor the bill, but they seem to have very few objections to what came over from the House. And that was in part because in the House they got the corporate responsibility language pulled, which was their big hold up with the original bill. I don't want to speak for them, but that's my understanding.
How you doing, Senator?
Oh, hey.
Snuck in behind you, so sorry.
Is that,
That's an accurate statement.
Senator Bones.
Is this one of the sections that it's been up just a little while since we've looked at this, but is this one of the sections that is aligning with federal law?
No.
We're just on the any firearm stolen, any value.
Yes, no, I know.
Yeah.
I couldn't remember which sections of the bill were simply aligning Vermont law with federal law and which ones were not. So.
Any other thoughts, comments, or recommendations? Anybody else?
What was the testimony we heard now for evening? Was it gun owners of Vermont? Eric Davis talking about felony part?
I think Eric's testimony was that he didn't, that the whole thing was intrusive on the rights of justice.
We did speak specifically on the felony as well.
Because you can't get a hunting license, right? Or not a hunting, you can't purchase a gun after that. Kind of an example where there was somebody in the community. I shouldn't probably speak on it. It's real testimony, but I thought there was somebody in his community that had this pertain to them, and they've since, come back around.
Well, you can get your firearm rights restored on down the line once you've gone through the judicial process.
If you have a felony.
Yeah.
You have a felony. You can't, right?
Yeah, they go for those health reasons. They can get.
State law says non-violent felony.
Well,
Couldn't you?
federal law would
Oh, okay, yeah.
prohibit that, right? Or am I forgetting something?
No, that would be, this would be prohibited under federal.
Yeah.
If it's a felony, the felony is 5 years, I think. So yeah, that would be, but not state law.
They're both the reasons.
I was, but I answered my own question.
Well, in my own opinion, my proposal is to strike second one. I don't think that, personally, I think felonies should apply to violent offenses or sexual crimes. I don't think that, I don't think there's any evidence to show that making something a felony is going to discourage people from doing something. If somebody steals a firearm and they shoot somebody, they have much bigger concerns to worry about than a potential misdemeanor. That I don't think that increasing penalties, whether it's for drug offenses or property offenses, necessarily reduces the instances of those offenses, but collateral consequences do lead to people having their lives completely overturned or, disrupted. I'll provide the general anecdotes and instances that I've seen where, the folks that I've encountered who have stolen firearms, whether it was my time as a trooper or as a defense attorney, it's either younger folks who are breaking into cabins and stealing booze and guns. Bad things that shouldn't happen, for which they could be held accountable. But I don't know that necessarily getting a felony record for the rest of your life is the best course of action for that. I think that was the best.
I'm actually inclined to agree with you. What you steal, like stealing, what you steal should be the determining factor in whether or not you end up with a felony. But I also feel that way about the existing law that says the money or property stolen exceeds $900, because that again is an arbitrary. The action was the same. What you took shouldn't matter. So I'd also maybe suggest that in the underlying law we strike that.
Thinking any of that?
There's got to be a line of if you steal $1 million worth.
Okay, fine, but $900 feels incredibly low.
When, Eric, by any chance, do you happen to know when the $900?
I don't know the exact date, but I can do some back, and that might cause you to think about how you want to approach this, because there's a great number of statutes that use that 900. Because it's the exact question that you're talking about. I think it used to be 300, and it's going back years ago. And so a summer study committee was created to try and come up with what would be the right number. Now the times have changed. And I think chairs were Representative Corey was chair of Judiciary. I think Senator Sears was chair of this committee. And one body, I can't remember the House or the Senate, one body wanted 750 as the new threshold, the other body wanted 1,000. Now you can see where the 900 came from. So,
Well, I made the same argument with a lot of those other statutes too. Like if I throw a rock through a window and that window is an 800 or is a $200 window versus a $1,000 window, like the action I took was the same.
yeah, exactly. My main suggestion is whatever you decide, don't just make it in one place. Make it throughout all of them.
So
We probably don't have time for right now.
That make what else on the Judiciary if they fail.
yeah, and
It's also
also
study committee.
I think it's a good point to revisit this, but I don't know that it would necessarily, we'd be able to encompass all the areas in which the $900 exists. But,
Maybe we can put a study in.
or an inflationary thing, I'm sure that would, for law enforcement would want. Yeah, but that calculate them every year. Well, so going back to my original thought, I'm proposing striking section 1 for the changes to section 1. Sounds like there's at least 3 people in support of that. I don't know if you want to take an official straw poll, or are there any counterpoints that you want to be raised?
Maybe I could, if I could ask Chris another question. Chris, to what extent, would guns that are stolen typically be over 900 or under?
Most pistols, like blocks, are well under $700.
Okay, so I'm thinking the most likely is probably people getting guns stolen out of,
I think that's different.
or hunting camps or car glove boxes when people leave them, which they shouldn't, but I know in Burlington, that's, one of the most common ways. So you're saying that those would generally be under 900?
Long guns would be more likely to be over 1,000.
Yeah, okay. I don't have a dog in that fight, and I could go along with striking that, and it would be better for the conference to work out.
Sarah Norris, or we're going to do another.
No, I was just gonna say to your point about if there's an action used with a stolen firearm, that would be the biggest consequence of the firearm itself stolen, right?
If you're stealing something so you can resell it, or because you're
committing a crime down in the town.
But if you're stealing something and then shooting at something, that's a bigger problem for it.
And it's still, and just to your point, it still would fall into this category if it was over $900.
Yeah. So it's still somebody's long gun.
And while I recognize we don't have time to deal with it this year, that brings me back to my original point that that's arbitrary line in the sand. Like, so if I steal and this pistol, then it's not a felony, but now I steal a long, now it is. How am I supposed to know? Like, the action I took was the same.
Yeah, but it's same argument if you steal a 50-inch TV versus a 100-inch TV, it'll be.
Yes, which is why my underlying argument is that arbitrary number is also problematic. I would agree.
Sarah Norris, any thoughts?
No, I don't, it's great, unfortunately, it's good.
So first thing, striking, second.
Got it.
And second two.
This is also an increased penalty with all that's going on in this section. With the existing provision of law regarding persons convicted of violent crime who are prohibited from possessing firearms. Under the current law, it's always a 2-year misdemeanor. That's page 2, line 16 to 17. And the proposal is, or I should, before I go past the House, is that for a second or subsequent offense, it becomes a 3-year penalty. That's the only change in this section. Let's go. Yes, that's the only change in this section.
Eric, does it have to be a violent crime with a firearm? Or is it just a person who is prohibited from possessing a firearm if they're convicted of a violent crime without a firearm involved? It still increases the.
Yeah, like for example, if you commit homicide by stabbing somebody with a knife and you never had a firearm on you, then you've got a violent conviction on your record and you can't possess a firearm.
So,
Maybe that's,
Yeah, and if I'm reading this right, the second offense is actually a third offense. Because they were convicted of a violent crime, then they were convicted of having a gun when they shouldn't. And now it's the second time they've had a gun when they shouldn't. That's total of 3 crimes.
3 crimes, but not 3 violations of this statute.
But my point is, we're looking at somebody who has violated the law 3 times.
Correct.
Yeah.
Oh, okay, I was reading it the other way. I was reading it after somebody already shouldn't have a firearm, then commits.
That's right. But what I'm saying is that means that overall, they've broken the law 3 times. Yeah. So I'm fine with this.
Okay, yeah.
That's 3's a pretty clear pattern that they're not gonna be regulated.
Sarah Norris.
yeah, Eric, so I'm looking at persons prohibited from possessing firearm after the conviction of a violent crime.
Right.
Is there a violent crime on the books that doesn't rise to the level of a felony to begin with, or?
No, they're all done.
We already have a statute covering that. Or they're a felon, convicted felon.
Yeah, it doesn't cover all felonies, but yeah, this is existing law. Exactly. All this does is take your existing statute and say, hey, if you possess that firearm after you've got that conviction and you were convicted and then you possess it one time, then you get the misdemeanor. But then even if after that you possess the firearm again, then you get that increased penalty for possessing the firearm while you shouldn't have.
It's under state statute.
Correct. Yeah. There's federal law that covers the same.
The prohibition is a lifelong prohibition, yes?
Correct.
So I hear Senator Brewer's point and want to push back a little because what I'm seeing is that someone could have, looking at the list of violent crimes, someone could have been negligently operating a motor vehicle when they were 19 years old. That person was seriously injured and now they're 50 years old and they have a firearm. And now that's that second violation. So I don't know that it always indicates a pattern of conduct, because some of the things on the violent crime list that prevent you from owning a gun forever, I don't know that in my mind would immediately be obvious. If that makes sense.
It does. I just want to make sure I'm understanding correctly. Are you looking at page 4? line
Yes, I'm looking
16?
at the list of violent crime means.
Those are exemptions.
Oh.
Violent crime, we need the list of crime,
We
except
carved those out.
other than.
Oh, okay.
Other than, yeah.
So that was exactly what happened, was they went through the list of all the crimes on most of the crime lists. That are these really the type of things that should be protected firearms? So they carved those out.
Okay, but if I go to page 5, I could have, given at 19 years old, given my buddy in college some ecstasy, and now I'm 50. And because dispensing is in there, and that's just giving it to the person, and now I'm 50. I haven't used ecstasy in 30 years. And I get caught. I don't realize that sharing ecstasy with my buddy at a party when I was in college is a violent crime prohibiting me from owning a firearm.
I cannot recall. I feel like, and I'm only not fully remembering it. I thought dispensing was specifically defined in a certain way, but
Yeah,
I could be wrong on that.
it's the sharing of drugs. So selling or dispensing. Selling is if there was a new money exchange.
Yeah.
Dispensing is there is no money exchange.
If it includes that, then you're right. That's what that would be counted.
Yeah. So I
If to be convicted though, right?
yeah, but I feel like if I'm 19 years old and I'm, I share ecstasy with a person at a party, not a great thing to do, but now it's been 30 years. I don't use ecstasy anymore because I've grown up. That's not a thing that I do. And I might not even realize that for the purposes of firearms ownership, that was a violent crime. And so I think that this sort of idea that it's an obvious pattern of behavior may not always be true. That's all I'm saying.
Well, whether it's still a fact that the person violated the law 3 times, and the last 2 times were this, he or she can't say when they have the gun the second time that they didn't know it was someone.
And so with that in mind, what would the second or subsequent offense enhancement seek to accomplish?
I just think that like all our graduating offenses, it's in part meant to be deterrence, but in part just proportionate to the danger that's being evidenced that the person won't modify this behavior, or doesn't seem to modify this behavior.
So as it is now, it's just always that first line 16 and 17.
Yes.
Each offense,
Yeah. So 2 years.
not 1, 2 years.
Yeah.
No, most.
History.
But the enhancement moves it to a felony.
Right.
But that same person still can't possess a firearm regardless if this section is misdemeanor or felony, right? Because they're already a person that can't possess.
Exactly. Yeah.
And what is the federal violation? If there is, I assume there is one.
There is one. I don't know off the top of my head, but I can run that up.
Do you happen to know if it's a misdemeanor or felony?
I think it's a felony.
It's a felony right off the bat.
Yeah.
This is not aligning with federal law. First offense, federal law is a felony. We had a discussion actually with senators here, so they couldn't understand if we were going to get tough with it. I'm sorry, Chris Bradley, Vermont Federation of Sportsmen's Clubs. I couldn't understand because now you have a situation where one person can be charged under state law and have it be a misdemeanor. Another person doing this exact same thing could be charged under federal law and it'd be a felony for the first offense.
Well, there are misalignments throughout titles, right?
Yes, that's our side.
So are there any thoughts, recommendations, suggestions for this section?
I support this.
I mean, because it aligns with, it's getting us closer to alignment with federal law. I guess I'm sort of agnostic. My larger concern is the underlying list of what constitutes a violent crime.
I mean, I don't, at least that's my own perspective, I don't use the alignment with federal law as necessarily the guiding beacon as to what our laws should or shouldn't be. Though it depends on what the specific policies that we're talking about. That means it's reasonable for a state to say, we think this conduct should be a misdemeanor or felony. And it's also reasonable for the federal government on its own, independent of Oregon, to say, we think if this conduct happens and it's in our jurisdiction, it should be a misdemeanor or a felony. I think that's.
From just a purely maybe you can answer this as an attorney, but so if person A and person B do the same thing in Vermont, one person's charged in state court, one person's charged in federal court. How would that, so my concern that I'm trying to make sense of is, can it be arbitrary? And I decide I don't like person B as much, so we're gonna charge them in federal court for the bigger crime. How does that work?
My answer is it depends. I mean, every situation is different, and there's a million variables that can happen. If somebody is state custody and they're working through their state cases, they'll have and they also have pending federal charges because the feds picked up on something that happened and then did their own investigation. And that person resolves their state cases. The feds will be waiting for them as they leave to have their federal charges addressed next, unless they're resolved in a sort of global agreement. But that gets really complicated. Yeah, I don't think that really answers your question.
It sure doesn't. Is there an instance in which person A could be charged in state court and federal court for the same crime? In this instance, illegally possessing a firearm?
I mean, the conduct could be similar and there could be a nexus, but the federal laws. I guess the short answer is sort of yes. It depends.
It's not really agnostic. If you say it can go. My bigger concern, like I said, is that some of the things that we're constituting as violent crimes that don't actually involve any violence.
Yeah, I mean, I generally have hesitation on felonizing things that aren't, when the conduct itself isn't sexual related crime or violent crime. I understand the origination of this offense comes from somebody who's being convicted of a violent crime. But to your point earlier of somebody sells ecstasy and then gets one charge and then 50 years later they don't realize it. They deserve a felony. But I guess if we can just leave it for now, unless there are other thoughts on this issue. Anybody else?
I thought you're moving towards going in section 2, right?
I mean, you can propose. Section 3.
Yeah, this involves another category of what's often called prohibited persons, right? Persons who are possessing firearms. We were just talking about the category of what is sometimes referred to as felon in possession, not always a felony, but it's persons who've been convicted of certain crimes. Every state has a provision like that, so does the federal government. Then the Congress also has, as do other states, other categories of people who are prohibited from possessing firearms. Vermont law has a few. You'll see there, the existing ones are on page 6, subdivisions 1 through 4, fugitive from justice, someone who's subject to a final legal abuse order or order against stalking, person against whom certain charges are pending. So the proposal was to add another category, and this category also is one that's although not identically, it's a category generally that's also covered in federal law and the laws of other states, and that's people who are prohibited from possessing firearms for mental health reasons. And as I say, federal law does cover that. It's much broader than what you see in front of you. This proposal is to, and I should back up to all of Vermont also has a reporting provision currently on the books in a different section of law, which provides that people who have been committed involuntarily for mental health reasons, certain groups of people who have been involuntarily committed have to be reported to NICS. And in that case, they would be included under federal that case. This proposes, but there isn't a separate offense, a separate existing offense in Vermont law that says, hey, this group of people is prohibited from possessing firearms. That's what the proposal is here. It takes a subset of people that are covered by federal law. And that is people who have been involuntarily committed after findings of not guilty by reason of insanity or incompetency to stand trial under certain circumstances that are laid out. And either the permanent prohibition applies if they've been convicted of not guilty by reason of insanity, but violent crime or incompetent to stand trial for one of those offenses on page 6. In that case, the person prohibition is permanent unless they file, as we were mentioning, there's a court process they can go through to have your firearms right restored. So you have that sort of offer. But otherwise, the prohibition lasts permanently. But if you've been subject to a commitment order for something other than a violent crime or hospitalization order, so to something other than that, then the prohibition only lasts as long as the order is in effect. So it's kind of like that stalking order RFA situation. That prohibition lasts as long as the order is in effect. Once the order goes away, prohibition is there. So that's the big picture. I will say that the Departmental Health Council, well, I don't know the specifics yet, said there might be a language change to this. They haven't changed the sort of fact, but just want to correct the committee that they're, and so I don't know. Thought on that is, I will say it before fact.
Just a quick question here.
Yeah.
Right. I don't see any wording. We haven't had a discussion about temporary relief from abuse and burning with firearms. I don't see anything in here in reference to a temporary, finally, relief from abuse.
That's the relinquishment that isn't in here. I'm gonna propose adding it a bit later. There's still some language that has to be tinkered about with it, but it's not in this draft, but we did, that was the presentation that we got Carol said just 2 weeks ago at this point.
I'll hold my question until then.
Okay.
I was wondering if that language was the language you were referencing.
About from DMA 3?
Yeah.
I don't know. I'm not sure exactly what their perspective on. I think though, and I again, I'll follow up on this. I think that that right now, if the prohibition only applies to final orders, RFAs and stocking, that's lines 8 and 10, it's existing law. I think that federal law as well has to be a final order, so that if you were to make it prohibition apply also when it's a temporary order, just so you know, that would be an expansion beyond the federal law prohibits, which you can certainly do as a policy matter. Be aware of that.
So I'm confused a little bit on some existing language. It says that see on page 6 is carrying a dangerous weapon while committing a felony, and that you can get a charge for violating the section. If you're in possession, you've got the misdemeanor, but then there's also the enhancement for the felony. How does that go parallel with the other with the other statute that we were just talking about, somebody who's convicted of a violent felony,
Right.
you know, can you get two? I don't know how to phrase my question or I'm not sure how to articulate my confusion on this, but you get where I'm coming from with how it seems like there's two potential tracks and exposures to liability of that.
Yeah, and I think it depends whether there's been a conviction or not. Right. So if there's been a conviction, you're subject to the first section. Presumably the charges wouldn't be pending anymore, right? So you know, so there's sort of that moment of conviction. This one wouldn't apply because they're not pending or convicted, but the first section we just looked at would. For, as you see, a very small number of offenses, A, B, and C, it doesn't require the conviction, right? Only the charges are pending. The federal provision on that applies to all the same broad range of felonies that the federal law prohibits possession of, but it uses the phrase under indictment for. So that's kind of the idea. Same conceptual idea. This was an addition that was made in the context of the juvenile crime bill that really came out of some back and forth between the House and Senate about whether to expand the Big 12 to include all a number of other offenses, and it was just sort of legislative compromise to ban this in that way. So I don't think it was part of the bigger picture policy other than that. You know.
Any questions or comments on this? Well, I do again have the same concern of having the felony now being included for people who may not have had an originating violent crime, but may just be incompetent to stand trial. Oh, but it's listed for a offenseless and subdivision. Are those the violent crimes?
Where are you now? Sorry.
Sorry, I'm looking at page 7, lines 3 through. And then the offense itself, which is on 17, 14, both on page 7.
Right. So yes, this does the same thing that Section 1 did in the sense that if it's second or subsequent offense, it's a felony. So possessed in front. So that part is parallel.
Right. So I guess my question is, what were the offenses in subdivision 4, subsection A?
Yeah, that lines 14 to 18 currently. Also pointing out page 6.
Oh,
those are the ones we were just talking about. That yeah, just a handful of offenses that. Right. Yeah, it would just be lines 13 to 18. So those 3 offenses.
And so, okay, so I'm also looking at.
There are that witness, right?
Yeah, but it's fine.
Right. We'll get started maybe 5 or 10 minutes.
Yeah,
All right.
that's pretty good.
Lines 8 through 10. Somebody who's subject to an order of non-hospitalization, say because they're suicidal, and they don't go through the process to get their firearm rights restored, but and then years later they get arrested for being in possession of a firearm. They get a misdemeanor. Then many years later they get arrested a second time. They can be charged with a felony.
Only if the order is still in effect.
If the order is still in
Yeah,
effect.
because that one is the 2 and 3 are different than 1, Roman 1. Because you see line 5 and line 8 is the subject of. So for those ones, they only have, the penalty is only incurred while they're subject to the order they possess. So the idea is to kind of track the existing language in lines 8 and 10, page 6, relief from abuse orders, stalking orders, only the offense only happens while you're subject to the order.
That is, thanks, thank you. Any other questions or comments? Anybody else?
This is the section that both under state and federal law, you can apply to have your rights restored, yes?
Correct.
Not in the instance Senator Jane brought up, because that would automatically, your rights would automatically be restored when
The order was lifted.
the order was lifted.
That's right.
Okay.
Nobody else? So that leaves us with section 4 and then also section 5. I know that I don't think we'll be able to get through those in a few minutes or but yes, we'll come back to this on next week. Any closing thoughts from anybody? Any additional things that we want to add to this or take away that you want to start the conversation on? We'll put a pin in for next week.
I know we've had conversations seriously about the 72-hour waiting period, online sales, and utilizing, because there is shipment time that between when you order it to when it gets delivered to an FFL, that could encompass that 72-hour waiting period right then and there. Would it be open to looking at bringing in the shipment time can count towards that 72-hour?
It would automatically do that.
No.
I don't think so.
Well, you're talking about from when you order it, but not from when you go to the dealer?
So when you order a firearm online,
Yeah.
you buy it, you have to say what FFL it goes to. It goes to an FFL, and then you say it takes 5 days for that guy to get there. You have to then go get your background checked and then wait 72 hours. But realistically, by that time, if it took 5 days to ship, really 8 days that the waiting period is
Right.
happened from what I understood.
We can't expect the background check to be initiated until we go to the FFL, right?
Right, but your 72 hours would already pass. Like if you go get your background checked at FFL and you're denied, but if you pass right then and there, that 72 hours already passed from when you thought about purchasing the gun, actually purchased the gun up until the point.
I'm missing the,
If you go and get your background check, right, then usually only take, it's very brief.
Yeah.
If you're gonna get a clearance, so you
Yeah.
comes back to you, hey, I can purchase this. Under the ordinary waiting period, you can't take the firearm right then. You've got to wait 72 hours, even if it took 5 days to ship there. So I think the idea for the policy, you guys think about it is, well, if the shipping was already, say, at least 72 hours, if it already took that amount of time, then maybe you can take the firearm right then because you had, the waiting period happened during the course of the mail.
And
the background check. And the background check.
Right, and that's the background check, right?
yeah, as long as it's 72 hours after the background check.
You purchase it online, you spend the money, it gets shipped
Yeah.
to the FFL, takes 5 days to get there. You show up at the FFL, you get past your background check, you do your background check, they can be immediately released because it's been over the 72 hours.
That's,
You know what I mean?
I think there should be 72 hours from the background check to when you get the weapon.
But if the 72 hours is like your cooling off period, that's already
Right, but I mean,
when you thought about purchasing a firearm,
yeah,
it's taken now 5 days. And then the background check is right then and there, and
Yeah.
if nothing pops up, where they have it.
yeah, I'm speaking for myself. I wouldn't go along with that. I think the FFL should begin the background check process and then 72 hours later, you get the background. So what you're talking about, I think, is somebody orders something online, then when they show up to the FFL, they immediately get the weapon. As long as it's 3 days.
That's as fast, because when you first initially had that thought of purchasing a firearm,
Yeah,
it's been past that 72 hours.
No, I see the case you're making. I would. So,
Yeah, it's
Just throwing it out there.
Yeah.
Just throwing it out there.
support of it.
The 72 hours was an alignment for that sort of like mental health. We can hold someone for 72 hours, you know, to sort of gauge where they're at. My understanding, and it's been a while since we've done this, is that in an instance where you do the background check and it comes back sort of inconclusive, that triggers a different, longer waiting period for, is it 10 days, 30 days? Do you know
I
what
can't
I'm
remember. Yeah.
There is an additional period. I can't remember the precise number of days, but I think it does.
I think it's 2 weeks, but since there are weekends, it's effectively 10 calendar days, something like that. 10 business days.
So if I don't know how you would craft this, but that's why you're the attorney and not me. If it gets there in 24 hours, then no, I have to wait
You have
the
to wait
additional
another 48.
48.
Yeah.
But if it gets there 5 days later and I go in and I pass my background check, I
Okay,
don't,
but how does the FFL know when you ordered it?
So, I mean,
They're notified by,
are they notified when it's ordered?
aren't they
I mean, I think
notified by
it's-
the manufacturer?
definitely a good idea to get FFL and, you know, I know firearms aren't shipped in, you know, unmarked, well, they shouldn't be shipped in unmarked boxes with no tracking information whatsoever. You know, it's possible to know when firearm is left the manufacturer or the online seller. I've been in transit for 72 hours. And if it has been in transit for at least 72 hours, the buyer has not been in possession of it for at least 72 hours since they made the decision to make that purchase. So,
But I mean, in the case of the FFL, you have this licensed dealer who's conducting a background check, the clock starts. If we're talking about accepting data from outside dealers, you know what I mean? Like, they will, how would they convey in an authoritative way when they're shipping it? Because it's not all going to be uniform. Maybe there won't be any shipping data on some of them, but the person says, I ordered it a week ago. It just seems to me that you open the can of worms of you're accepting the word of whoever is selling guns online, not necessarily among FFLs.
well, I think it would be a valuable question for an FFL, presuming they keep a close, a highly detailed log of when firearms are arriving at their shop.
Right, but not, they won't know when they were ordered.
I would imagine it's the same as them getting a firearm from the manufacturer, that they know exactly where that firearm is when it leaves.
But they don't know, they don't have any responsibility for it till it arrives at their shop. So why would they be keeping logs of when it's shipped? I mean, that's gonna be on the private seller. So I mean, then you're basically farming out the job of maintaining the clock to any independent dealer who's out there.
I mean, I know exactly when I buy something from Amazon when it
No,
leaves,
you do.
and Amazon knows,
Right, but I'm just saying,
and FedEx
the way
knows.
we have it now is the FFL is the only keeper of the clock. And what we're saying then is that any private dealer anywhere in the world is now, we're gonna depend on them for the information about when the firearm was ordered. I just think it'll lead to endless disputes where people say, I ordered it 5 days ago. There's no information reliably to back that up. The way the law is now, only the FFL can conduct a background check and stop the clock. And I just think this opens up a whole lot.
Well, let's revisit the conversation, perhaps with an FFL in the witness seat as well.
Yeah, maybe.
And then, yeah, thanks for raising it, but I also want to make sure we get to our next witness and, then we'll have the floor. So, thank you, Eric.
Yeah, thank you. Yeah, you got.
Sorry for the wait.
No, thanks for your flexibility. I had a conflict at 10:30 that I couldn't get out of, so, and I didn't realize about, days ago. Thank you, sorry. So, I'm just, here to testify about part of the miscellaneous judiciary bill. My name's Kristen Fountain. I'm, the coordinator of the Vermont Journalism Coalition. This is a section that would repeal an existing prohibition on accessing criminal records online. And it was put in the miscellaneous judiciary bill by the House because, as you'll see in the record, it was uncontroversial among all of the players in the court system. So we're just starting from that baseline. I'm primarily here just because I thought this would be a great opportunity for me to talk about why it's important to my constituents and my members, and also to introduce the organization and answer any questions. So I don't, this is something I think there's widespread agreement about. So I'm not trying to create any questions. I'm just wanting to emphasize that this will make our lives a lot easier and is important constitutionally. So just to say, the Vermont Journalism Coalition is a relatively new organization. We started last summer. We represent media organizations of all types, from television and radio to digital only, to newspapers. We have 42 members, and the concept of why this was important is like that because technology, media has changed so much in the last 10 years. We have radio and TV that are doing news writing. We have digital only publications doing podcasts. Everybody's doing everything. So the basic fundamentals are things that we can all come together about and discuss and strategize and advocate. So that's the general concept. So as I said, I just want to explain why repealing this prohibition is important to our members. And first, just want to acknowledge, which you'll see in the House record, research and thinking done by the Media Freedom and Information Access Clinic at Yale Law School and the New England First Amendment Coalition. They did some research into the prohibition, which I didn't really know existed. And they sort of looked at the history of it and what the current legal context looked like for it. And they determined that given recent decisions in our circuit, that the federal courts would likely consider this an unconstitutional procedural delay or impediment to accessing public records. So that's just one piece of it, right? But the short version of what they found is that this prohibition on accessing criminal records remotely was put in place 20 years ago when all court records were still on paper, and there were no court rules in place about safeguarding confidential personal information in public filings. So even when it was put into place in 2000, the year before it was put into place in 2007, a legislative committee studied whether this should happen and recommended against it. They said criminal records actually should be available online because, like civil court records, they are public. So right now you can go online, you can access the entire docket, all the documents related to civil court records. You cannot do that with criminal court records. The only thing available online to the general public and to journalists is the calendar, literally. And I'm going to talk more about that now. But in 2008, this committee in particular inserted the prohibition, and it went into state law. So meanwhile, over that same period, as we all know, the technological changes that made digital court filings the norm and allowed lawyers and judges to submit and review them through a website from anywhere has also upended the business model that sustained journalism, right? So Regal Local News is a national group that I also represent here, and they have analyzed in more detail information gathered by Northwestern University's State of Local News Project. And they estimate that between 2013 and 2023, the Vermont news business lost half its working journalists. That's a lot, and overall 400 jobs. That's a big loss. And what that means is that there are fewer people reporting on the daily business of everything, but also the state courts, right? And the journalists that do are also responsible for trying to inform communities about a wide range of other topics. And the majority of our members are these very small, local, regional
newspapers and websites. They make up the core of our membership. And these journalists and editors are also uploading stories, laying out the newspaper, delivering the newspaper. Like they have many, many other jobs. These are staffs of 2 to 5 people generally. So currently for journalists and the members of the general public to see criminal court documents, they have to drive to the county courthouse and use a designated computer terminal there to access Odyssey, or what's now called something else. I mean, they can also request very specific documents by sending a form to court staff by email, right? The truth is these terminals sometimes are not functioning for technological reasons, and access is limited to courthouse open hours. The email request to court staff can require several back and forth exchanges, depending on how familiar the requester and the answerer are with the case and the file names and what making sure they got what they wanted. So the creaky system can work, right? We have some experienced reporters who have longstanding relationships with court employees who can help them find documents quickly. I mean, this does happen, right? But they have to know when to reach out and ask, and they have to rely on court officers and lawyers who also have many other jobs and tasks that they're trying to accomplish, right? So this is all just really unnecessarily time consuming for everyone. And with fewer reporters trying to do more, that time to my members is really precious, right? Like, for example, I met yesterday with the editor of the Hardwick Gazette, which covers 11 towns in 4 counties. He is 25 minutes to any county courthouse from where his office is, a 25-minute drive, right? Their newspaper, like many, publishes news from the police about arrests. And this is not just for assaults and murders. This would be for driving under the influence, drug dealing. I was just trying to get theft, right? Kind of small, lower level crimes. They don't have the capacity right now having to drive that distance or make these special requests to follow whether these charges are actually filed, what kind of charges are filed, how the case turns out. And that leaves the general public really with almost no information about the basic functioning of their courts, right? So repealing this prohibition in the end is not just about making our jobs easier or reducing the burden on overworked court employees, though it will do both these things. Fundamentally, as we all know, opening up state records of all kinds, but particularly in the criminal courts, public scrutiny is really essential to maintaining public trust in how the court functions, right? So the public has a right to access these documents under the state and federal constitution, and in today's world, that means they should be able to review them remotely online when the records right now are submitted digitally. And there is a content management system already in place that works quite well for civil court records. In conclusion, my understanding is back in 2008, when the legislators put in place this prohibition, the idea is that they were protecting people's reputation and their privacy, which is an argument. But today, when there's commercially available artificial intelligence that can produce official looking documents within minutes and put it out on social media, the situation is very much the opposite. So giving the public and the press a way to efficiently access criminal records helps us to quickly assess these rumors and to combat false information online. So,
Thank you.
yeah.
Am I right in that, my understanding that those are records that you can and will get?
Yeah.
Currently, it will just take longer.
Yes. These are all public documents. They're just inaccessible to us in an easy way. So we're very pleased that this is happening. It's been something that my members have tried to sort of have happen within the court system, and I think finally we got organized to ask the right people to make the change. So we appreciate it.
Thank you.
Yeah, thanks very much.